Do you know that I got 98 in criminal law 1 in regular class? And Luis Perez, the professor, his attention was called by the secretary of the Institute of Law of FEU. He said, Judge, hanggang 95 lang ang pinagtakaan. Eh, sabi niya, no, hindi deserve it. Sa yung transcript ko, 98 ako sa criminal law. Binibilugan ko pa nga yun. Pag ginagamit ko sa employment. And I think this is how it came about. It was recitation time. Criminal law 1. The problem given by that good judge, he became a justice. Also, Luis Perez. Eh yung ang penalty na i-impose ay reclusion perpetua. Ako naman, to the letter. The indeterminate sentence law says, it is not applicable in case the penalty was death or life imprisonment. So, almost roll call, 5 lahat. Pagdating sa akin, nag-aatubili ako, no, ako, yes, the indeterminate sentence law is applicable. He looked at my card, oh, you are one among those who are very good in it. Almost perfect. I'm sorry. Binigyan ko ng 5. Eh, 5 deep. The next to be asked was Antonio Abad. Now then, also your reviewer in labor. He graduated cum laude also. He topped, one of the top, and when he took the bar. Eh, magaling si Tony. So sabi niya, I don't think the determinate sentence applicable. Sabi, yes. So, uno siya. But then I raised my, I said, sir, oh, hihirit ka ba? What is it? The indeterminate sentence, I said, does not provide, does not state reclusion perpetua as one of the exceptions. You know, siguro that was the first time. He got it, and they said, you were correct. But, sabi niya, magaling yung mali. Oo, rin. But, the Supreme Court has always ruled that in case the penalty imposes reclusion perpetua, the indeterminate sentence is not applicable. That may be so as your said. However, there is a way of difference, and you must know it, between reclusion perpetua and life imprisonment. Reclusion perpetua is provided for under the revised penal code. Life imprisonment is provided for in special laws. Life imprisonment virtually has no duration. Virtually, you can be imprisoned for the entire life. Reclusion perpetua has a duration, 30 years, under Article 27. And life imprisonment has no accessory penalty. Reclusion perpetua, I said, has accessory penalty, which was later on formalized in one case by the Supreme Court. And he looked at me. Okay, siguro kaya ang graduate 98. He has predicted I think the faculty members here and may chance daw tayo sa top 10 sa inyo. We hope so. And they always said we are potential backup potential. So that's the reclusion perpetua, death, life imprisonment, and reclusion perpetua exception to the application of the revised the indeterminate sentence. Meaning to say, if that is the penalty, do not fix the minimum and do not fix the maximum. In case of treason, conspiracy and proposal to commit treason, misprision of treason, piracy, rebellion, sedition, and espionage, the indeterminate sentence is not applicable. Do not fix the minimum and the maximum term. It would seem, if you are careful, if the crime is conspiracy and proposal to commit rebellion under Article 136 or proposal to commit sedition, it would seem that the judge should apply the indeterminate sentence law. Because the law says treason, misprision, treason, conspiracy, proposal to commit treason, rebellion, sedition. There is a crime of rebellion and conspiracy and proposal to commit rebellion. There is a crime of proposal to commit sedition. If that is the crime, and the penalty must therefore be containing minimum term and maximum term. If the accused is a habitual delinquent, some of you may not have a good idea of habitual delinquent. Remember under Article 62, the last paragraph, if the prisoner, if the convict shall be found guilty a third time or over the crimes of falsification, serious and serious physical injuries, falsification, estafa, huerto, theft, robbery. A third time or oftener for a period of 10 years, the accused is a habitual delinquent, and there will be additional penalty. Okay. At least 3 convictions. Let us say, for the first conviction, falsification, accused A was sentenced to 1989. Sentence for falsification. And then was sentenced to estafa. He is not a recidivist. If the question asks of you, can a person be considered a habitual delinquent but not recidivist? A recidivist is one who, at the time of the trial for one crime, shall have been previously convicted of another crime, embracing the same title of the court. Falsification is not embraced in the same title as estafa. 1991, estafa convicted him. Then he was convicted of serious physical injuries. 2000, 2001, 2002. In the SCR is he a habitual delinquent? If within a period of 10 years, a convict, an accused has been convicted of any of the following crimes: serious or racist physical injuries, theft, huerto, estafa, falsification, he is a habitual delinquent. Baka malito kayo dun sa within a period of 10 years or oftener. The 10 years, if you will compute 1989 to 2002, more than 10 years ito. Ilang years ito? 11 years or 12 years? 11 years ito. From 1989 to the last conviction, 2002, 11 years. The last 10 years? No, that's not the computation. The computation is the 10 years must be computed from the first conviction to the second. Is it 10 years? Yes. From the second to the third. Is it 10 years? Within 10 years? Yes. He is a habitual delinquent. You compute from the first to the second, second to the third, third to the fourth to the third. Not from the first to the third, because you may be confused by the law a third time or oftener within a period of 10 years. The 10-year period is from the first to the second, from the second to the third, from the third. You get it? Okay. Habitual delinquent are exempted from the application. Meaning, say, if you are a habitual delinquent, hindi na ipipix ng court. Ang minimum at maximum, wala ka ng chance to get out in case of good behavior after serving the minimum. That is the only meaning of exception. If you have evaded the service of your sentence, you are also exempt. Meaning, the indeterminate sentence, you will not be entitled to the benefits of the indeterminate sentence law. And this is how it would apply. Para maliwanag sa isip mo. If an accused has evaded the service of a sentence meaning to say, so the accused was sentenced to homicide. While serving for homicide, he escaped. After his escape, he committed, let's say, robbery or theft, whatever, robbery. If found guilty of robbery, the court in imposing the penalty for robbery will no longer fix the minimum anymore because he has evaded the service of his sentence. Or when he has escaped from confinement, maraming nalilito din dito. Escaped from confinement. He was found guilty of homicide. Nagkasakit siya. Dadalhin siya sa hospital, asylum hospital, Bisagate. He escaped from the hospital. If he commits after escape, let's say, robbery, whatever, and found guilty in imposing the penalty for robbery, no more minimum and maximum. Hindi na i-apply indeterminate sentence. But you remember PD 603 and now Republic Act 9344. If the accused is above 15 at the commission of the crime below 18 and he acted in settlement, he is guilty. But the law says, Republic Act 9344 says, the decision shall be suspended. When I was a practitioner, he called up, paano suspended ang decision? This is the meaning of suspending the decision. I were the judge, 17 years old, acting with settlement. I found him guilty of homicide. Decision. He promulgated a decision. As an accused, so you are found guilty beyond reasonable doubt of the crime of homicide and sentenced to, let's say, 6 months and 1 day to 8 years. And then at the end of the decision, meron ako, may kulatiyas dyan. However, pursuant to the provisions of PD 603 or now Republic Act 9344, the sentence is hereby suspended. And you are ordered confined at the Manila Rehabilitation Center. And the officer in charge is directed to render a report about your behavior, etc., etc. Okay. He escaped from the Manila Youth Rehabilitation Center. After escape, he committed another crime, that's a robbery, and found guilty in imposing the penalty for robbery of the youth to escape from confinement. Will he be entitled to the benefits of the indeterminate sentence? The answer is yes, because the sentence was suspended. So the youthful offender is still entitled to the application of the indeterminate sentence for robbery, because the promulgation was suspended. In case of destierro, remember, destierro is the penalty to be imposed to a concubine. Alam niyo ang concubine? Yung kabit. Alam niyo ang kabit? Hindi ko ang meaning ng kabit. Hindi pinakukulong ng ating batas ang mga kabit. In fact, you will take note, under Article 332, a spouse who would steal the property of his or her spouse, if you are the wife, pwede mong nakawan ang mister mo. Because only civil, no criminal liability shall be imposed.